Jeffrey Warden appears apparently representing himself. Abby appears in this case along with her attorneys, Rebecca Mann and Emma Hockman. This matter comes before the court at this time for further proceedings in regards to a motion to modify respondent's parenting time, ADHD evaluation, and child support arrearage. This matter was originally scheduled to come before the court on April the 18th. When Mr. Warden didn't appear, even though it appeared he had been served by mail, Ms. Mann went ahead and called Mr. Warden. At that time, Mr. Warden, it's my understanding your claim was that you didn't receive the notice.
That is correct. Never got a notice in the mail.
So to give Mr. Warden an opportunity to appear and respond, the court rescheduled the hearing for today. Ms. Mann, it would appear that your certificate of service that you signed indicated that it was mailed out on March 11 to Mr. Warden, 2323 Southwest 157th Terrace, Leon, Kansas 67074. Is that when your office sent it out?
Yes, that's correct, Your Honor. And when I spoke with Mr. Warden the other day on the phone, he confirmed that that is his home address. We also sent it by email, and he confirmed the email that's also on the certificate of service. So we sent it both ways initially.
All right. Well, Mr. Warden, I resolved doubts in your favor on Tuesday to give you an opportunity to respond. Or actually, I think that was Monday of this week. Some of the issues I think need to be addressed sooner rather than later. What is your position here, Mr. Warden?
I'd like to request a continuance since I just found out about this 4 days ago, and I have no legal, no attorney or anything else. My attorney had quit family practice, Darren Patterson, and dropped me at that time. And I had no idea that we were going back to court at this point. So,
well, you know now, and you've known since earlier in the week, right?
Yes, sir.
Okay. Just looking at some aspects of this motion currently before the court. I'll ask the mother's counsel in this case. Isn't the mother empowered to arrange for this ADHD testing by a licensed professional?
Your Honor, I understand that there needs to be some sort of agreement between the parties to send the children to ADHD or any sort of behavioral evaluation, and that the father is not in agreement with that, and so that's why we're here.
Is that based on some prior order issued in this case?
That is based on joint legal custody, is my understanding. I do believe that earlier in the case, there was some sort of agreement where they were ordered to go to counseling, but the counselor is not licensed to do ADHD evaluations or other behavioral evaluations. She is recommending that they go and get these evaluations by someone who is licensed to do that.
All right. And how would this be paid for?
My insurance will cover, I believe, most of it. There may be a small out-of-pocket fee.
Okay. Mr. Warden, are you opposed to the children receiving this testing?
Yes, Your Honor. She's brought this several times over the past 5 years, and we have been prepared to argue it, and also have ended up agreeing on it before, court multiple times. That we have agreements on that we're not going to do that. Yes, I feel like it's totally ridiculous. I don't think there's any, we've been through it all many times, but I don't believe she's continued to test the kids, continued to have the kids in counseling since they were toddlers, and I'm just against all that. It's not been, we've not seen any kind of changes or differences. She continues to feel like the kids have issues and problems that I'm not seeing, and most people around the kids are not seeing or experiencing. But she wants to continue to do things that I feel like are not good for the kids.
All right. I see that the request is actually broader than just ADHD testing. As I understand the motion, there was also a full psychological evaluation recommended by a counselor in this case. Are you seeking permission from the court to conduct that as well?
Yes, Your Honor, we're seeking permission from the court to proceed with any sort of psychological behavioral evaluation that which the counselor recommends. And just as an aside, Mary Ellen, I think you're not.
There she goes.
Never mind, I got it. Okay. But yes, sorry, Your Honor. We are requesting any behavioral testing that the counselor of the children is recommending. We'd like to proceed with what her recommendation is.
Okay, and the Mary Ellen on this meeting is who?
I believe that is the mother's mother, grandma, who's interested in what the proceedings are.
All right. All right, ADHD testing is one thing, a psychological evaluation is another. Would this also be covered by the mother's insurance?
Yes, my
Very
understanding
expensive.
is that's understood, and I believe that it would be covered by Abby's insurance.
All right, is the mother prepared to cover the difference in cost between what insurance covers and what is billed in the case?
Abby is saying that yes, she's willing to do that and has offered that previously.
All right. Well, Mr. Warden, if you could just address this, if this court were to order that this testing be allowed, despite your objection, with the insurance to cover whatever it can and the mother being responsible for the rest of the cost, would you still have an objection to it?
Yes, absolutely.
It's just your perception they don't need it?
That they don't need it, and that it's continued hassling, that they've been continually hassled.
But okay, you're saying the children would be hassled by the testing?
Yes, sir. Yes, Your Honor. She's been continuing to say that they have things wrong with them and that they have problems, all kinds of problems, even though they do great in school, they're got great grades, and they've got so many good things that they're accomplishing, but yet she's continuing to say they've got issues and problems wrong with them, and is trying to find them as hard as she can for some reason, trying to find some kind of issue to put them on medication or whatever, the next step that they tell her to do. And I just, it's been the same each time. She's the only one that comes up with these issues and needs for them to be tested and total psychological evaluation.
But Mr. Warden, I have a professional recommendation from a counselor for this testing. Are you ignoring that?
Yes, because I have a big problem with this counselor. I've been met with her once. She met with my son once, Isaac, when he was in your chambers, you said you felt like he was 4 years old, more mature than his actual age. But she met with him for 45 minutes, I believe, the very first time, and said, "Oh yes, I think he definitely." She came up with the fact that he definitely needs tested and has all kinds of problems that she supposedly could see from first 45 minutes of talking to him. She has also told him specifically, and his mother had a problem with her too. Apparently my son Isaac was talking with the counselor and told her that he felt like the NFL was possibly rigged. They were talking about that for some reason, and she told him that he couldn't call himself a Christian if he believed that. And she just totally made a huge deal of that. And I've been told that he talked to his mother about it, and she told him that she's not happy with this therapist either. So I'm not sure why she's, just she's asking for her full recommendations. I believe just to accomplish her agenda again. But no, I'm not happy with the counselor or the therapist that they're seeing now.
All right. Ms. Hockman, do you have a reply argument to make here?
Yes, Your Honor. I understand that, Dad picked out this counselor, and so I'm a little confused as to why he would be, now all of a sudden, disagreeing with the counselor. I also understand Dad's only been to one therapy session with the children. So perhaps, maybe he's missing, the actual work that's going on between the counselor and the children. The counselor is the professional in this situation. And she has consistently recommended that the children get this sort of, evaluation testing. I think it makes the most sense to defer to what the professional in the situation is recommending. The children are doing, Grace is doing fine in school, but Isaac is struggling a bit, and we believe that ADHD testing would provide him with some, maybe with some resources for him to improve. This is what's in the best interest of the children, and I think that's the most important thing here, is to look at what the children's needs are, not necessarily what personal grievances we have against the professionals in this situation.
Okay, under the circumstances, Mr. Warden, I'm going to go ahead and give you the last word. Anything else that you would like the court to know here?
On this particular subject,
Yes.
the therapist also did say that she believes that my daughter and son should be having full every other weekend with me and spending regular time with me. I mean, that was one of her points that went against everything else, was that she, and that's why we did start back on the normal visitation after we had an issue back in that she has talked about there back in, last fall, I guess it was. There was a couple months that Grace did not come on the weekends with me, a period of time, and then we started right back in again. And I mean, it's been fine at my house. I really don't understand. I feel like that is the other subject, but it's the same therapist. So I mean, we're getting mixed vibes, mixed information from this therapist. I don't have any confidence in this therapist, and I'm trying to keep my kids on an even keel and having a normal childhood. That's where I'm at with it.
All right. And I'll turn back to Ms. Hockman. This motion was filed back on March the 11th. Has the girl, GW, has she resumed parenting time with Mr. Warden since March?
She has resumed parenting time, but is not, her symptoms of anxiety and distress have not paused or diminished. They're still there, but she has ceased refusing to go to Dad's house. And so she is having some parenting time.
She ceased refusing, but she's having anxiety over the visits.
That's correct, Your Honor, and she also will, as soon as she gets to dad's house, starts texting mom, when can I come home? I feel sick, please get me. Does not appear to be a healthy situation, as you can see in our exhibits from recommendations from the counselor that also.
Well, again, we shifted to a different issue. The court's going to rule on the first one. We're not necessarily talking about, nor is this court approving a course of action recommended by mental health professionals, except for further evaluation. And that's essentially what's being sought in this case. It is essentially evaluation and testing, not a new course of mental health treatment, not a new course of medication. This needs to be talked about seriously by the parents after recommendations are received as to whether the course of action recommended is really in the best interest of these kids or not. This court is always hesitant to put any child on medication. It can often lead to a downward spiral and not always have the intended consequences of improvement. However, in some instances, medication is very helpful to children. What category this case falls in is undetermined, but the court doesn't believe that it's appropriate to hold up psychological testing or ADHD testing that is being not just recommended by the mother in this case, but recommended by a professional, which apparently was chosen by Mr. Warden, especially when she is willing to bear the financial burdens associated with this testing and evaluation. So the court will grant that part of the motion at this time over the father's objection. The court understands it. But what we just need to do is get into his hands the results of that testing, the results of the psychological evaluations with whatever recommendations which might be included therein, as well as the results of the ADHD testing. They may come up negative, and there may not be anything further recommended at this time. But I think that for further testing and evaluation, it's deemed appropriate by the court at this time. So that can certainly be drafted into an order and submitted to the court. Regarding the suspension of parenting time, the mother is seeking that currently, despite the child's willingness to go see her dad?
I wouldn't characterize it as a willingness, Your Honor. The mom is trying to enforce what the court order is, and the child has ceased absolutely refusing. And by refuse, I mean the only way to get her to dad's parenting time would have been to pick her up and put her in the car to get to dad's house. That was the level of refusal that she was exhibiting prior. And she stopped doing that, but she is still communicating that she has headaches, stomach aches, will come back from parenting time and be clingy with mom and stepdad. Apparently also after respondent had a chance to review and sit down and review our motion, he told the daughter that, okay, if you don't want to come over and have parenting time with me, I'm not going to go to any of your or any other events. So this is an example of kind of the toxicity that Grace is feeling at this household. And it's not just mom's push or want, it is also what the therapist has recommended. We have a cease of parenting time, and we're only asking for a ceasing of weekends parenting time so that we're given the opportunity to really dig in and see where this anxiety and fear is coming from regarding the daughter's behavior and resistance to dad's parenting time.
How long do you expect that this temporary pause in parenting time would last?
I think that would be dependent on the therapist's recommendation. Right now, I believe that the kiddos are going to therapy every other week. Obviously, if this motion is granted and we do stop having weekend parenting time with dad, the parents would need to be work with the therapist to see what the next step and recommendation would be. I imagine a matter of months to be able to see, to do a thorough evaluation of what Grace's mental health is, what the issues of her mental stability and stress are regarding dad's parenting time.
Mr. Warden, would you like to be heard further on this?
Yes, sir. Grace's mother has allowed her to become addicted to media, cable TV, video games, internet, and apparently, according to Isaac, she spends most of her time in their house, in her bedroom, with her media. And that, I believe, is the root of the whole problem. I don't provide those things for her. Yes, she watches some TV. We watch some movies. You know, she does bring a video game with her sometimes, and I allow her to use that, but sometimes, but you know, I try to keep the kids busy with outdoor things and when they can, and other fun things. We do all kinds of different things when they're with me. But she, you know, she does have separation anxiety and all these other things they're saying because she wants to go do what she wants to do, Your Honor. And I believe wholeheartedly that that's what this whole situation is about. I'm not going to go into, you know, I know what, you know, now that her mother has conspired with her to do this. You know, when I did talk to Grace, she did tell me they had been talking about it. Her mother had told her that she was taking me to court on this. And I believe that they're working together at this point, and I'm not going to, you know, so I told her that I asked her if that's what she really wanted, and she said that is what she wants. And I told her I'm not going to fight her. I'm not going to go to war, and I'm not, you know, I'm not going to let her mother make an enemy out of me and my daughter by starting a court battle to try to, so that she can divorce me. So that's where I'm at. I'm at the point of just saying, hey, if that's what, you know, that's where we're at, then yes, I'm in agreement with, I mean, I'm not in agreement with it. I believe it's wrong. I believe it's evil, but I'm not going to fight it for staying with her mother and not coming to visit at this point.
Your Honor, if I can clarify, we're only asking for a pause in weekend parenting time. There was every other week, Grace would go to dad's on a Tuesday, and then the next week would go on a Thursday. So it's, I just want to clear that up because it sounds like we're asking for a seizure of all parenting time, and that's not the case.
Your Honor, there's nothing else. There's no other parenting time other than 4 hours a week. And we've been taking her to volleyball games on most of those lately. So, I mean, no, I feel like she needs to, if she's not going to come for the weekends, again, I don't want, you know, legal stuff and battles going on in my home when my daughter's there trying to, you know, I'm having visitation with her. So, I feel like if that's where we're at, then she needs to take a temporary break all the way around. I mean, I've told her, you know, if she wants to talk to me or see me or spend time with me, I'm definitely have made myself and will continue to make myself available to her. But if I'm not going to fight with her to come visit, is where I'm at with it, Your Honor.
All right. Counsel, would you check your calendar for the afternoon of Tuesday, April the 29th? And I would be looking at an in-person proceeding at 3:00 p.m. that day.
That's fine, I'll make it. We're available, Your Honor.
Court's going to order that we conduct an in-person proceeding in courtroom B, Butler County Judicial Center. This court will start that proceeding with an in-chambers interview of this 10-year-old girl. She'll be in the mother's custody, I trust, at that time. Mom, I would hope that there is some person that could come with you, that when she's done with their interview, I don't want her in the courtroom, but I don't want her on her own either. So is there some responsible person, adult, that could be with you, that could actually sit with her in the hallway until we've concluded?
Yes.
Okay. And I'm going to start off by an in-chambers interview with her, 3:00 p.m. Tuesday, April the 29th. Until then, this court will grant the relief requested, and I'm not going to go further than that. I'm hesitant to interfere with a father-daughter relationship as it is. The mother has asked for it. I think that there's reasonable grounds for this court to grant a request to put a temporary pause on weekend visitation between the daughter and the father. This does not preclude the during the week visits. It does not preclude the father from attending the girl's activities if there's some sort of public activity, a game, an event. It's up to him whether he attends those or not, obviously, but I'm not precluding him from any other of his parenting time rights. Only the weekend visits at this time are going to be temporarily paused pending the court's proceedings on April the 29th. I am going to ask that Ms. Mann and her office draft an appropriate journal entry stemming from today. Now, there is a third issue regarding child support arrearages. Mr. Warden, are you disputing that they've computed the arrearages in this case correctly?
Yes, Your Honor. Abby has known for 5 years that we made an agreement in our divorce decree that the arrears at that time, which were $9,152, were paid off through our agreements. And I mean, her attorney should know that as well. It's right in the journal entry of our divorce decree. Says, with the acceptance of this agreement, the respondent Jeffrey D. Warden's child support is paid through January 2020. So that's a known fact. And that takes care of it. That's about half of what they're showing. And then I've also paid $3,580 in March and April toward child support as well. According to my calculations, I'm about 3.5 months behind, and the past 5 months have made time and a half payments to trying to catch up with the child support that I know I'm behind.
All right. The prior orders of this court speak for themselves. This is a rather voluminous file. I don't know if this agreement that Mr. Warden is talking about is reflected by a journal entry or the original decree in the case. He says it is. Was this taken into account when this arrearage computation was done?
Yes, Your Honor, it was. And if I may offer, we are willing to, we did check the file and make sure that, if there was any prior agreement that was considered when we made our calculation. I'm not in a position to be able to pull the exact previous filings from years ago, but if you'd like, we could set this over for the 29th as well and make argument then.
That's a sound suggestion, counsel. I'm going to defer any ruling on the child support arrearage issue until the hearing on April the 29th. I will just expect each party to be able to articulate and prove their respective positions. The child support amounts are a matter of record. I presume through Kansas Payment Center, what's been paid is also a matter of record. We
Your Honor,
to determine exactly what his arrearage number is.
but Your Honor, her attorney at that time, Christy Simpson, did not follow through with what she said she would do in terms of straightening it out with getting it taken care of with the Kansas Payment Center, obviously, because it's on the Kansas Payment Center's records. It's you know, there's no record that they've done anything, but yet we have it in the journal entry. I have it in the journal entry available right now. I mean, that's from your court, that it was should have been paid off at that time. And Christy Simpson promised to follow through with that. As far as with the Kansas Payment Center.
Generally, the Kansas Payment Center records what's paid. They're not always an accurate reflection of what's owed. And that's what we want to try to determine so that we can reconcile the two numbers.
Gotcha. I understand.
Right.
Thank you.
We'll take that up further on April the 29th at 3 o'clock when we reconvene in Courtroom B, Butler County Judicial Center in El Dorado, Kansas, for an in-person proceeding with, obviously, as announced before, the court beginning with an in-chambers interview of the 10-year-old daughter in this case, which the court will order the mother to have there with a responsible adult to be able to take over supervision when the court has concluded its meeting. Any questions about that from the mother side of the case?
Your Honor, if I may ask a question about the first topic that we addressed, the behavioral evaluation. Mom has already found someone that is in network and is appropriate for this. Is it permissible for her to just go ahead with the professional that she has selected?
Yes.
Okay, thank you. No other questions, Your Honor.
All right, and with her being responsible for any pay differential between what insurance covers and what these evaluations cost.
Yes, Your Honor.
All right, very well. Anything further from Mr. Warden's side today?
Don't believe so.
All right, I'll look forward to receiving the journal entry stemming from today's hearing, which I'd ask counsel to treat as a priority. I think it's important to have that on file at the earliest possible date that we can under the circumstances.
Agreed.
All right. At this time, the court will stand in recess until 3 o'clock p.m. on April the 29th, when further proceedings in this matter will be conducted.
Thank you.
Thank you.
Meeting may be ended for all.